Now, I would like to invite our Honorable Dean.
A very good morning to all of you present here. On behalf of the CMR School of Legal Studies and on behalf of the Board of Management, I deem it a great pleasure to welcome all of you to this August function. The Karnataka Government Department of Science and Technology, with the assistance of the CMR Law School and other bodies, have been rendering wonderful service. And one such program we are organizing today is the awareness program. And the awareness program on intellectual property rights is the most relevant. And most of us and most of the people who live in the villages, although are capable of producing many things and owning intellectual property rights, they are not well informed. And the very purpose of organizing a seminar of this type and a lecture of this type is to know that at the rural level, the task force appointed by the government, as well as by other bodies at the state level, should be in a position to bring in lots and lots of information to the people, so that the product which is being produced by them will be in a position to get protected under the law. India is on the verge of becoming a developed country. And when it becomes a developed country, most of the things which are considered as part of our intellectual property rights are protected abroad. And there is a Herculean task in getting back these products which are essentially ours. Simultaneously, the products which are grown, homegrown, and which has a lasting, durable value has to be protected. And in this endeavor, a seminar of this type naturally will serve a good purpose. Now here, the concentration is mainly on geographical indications, trademarks, and intellectual property rights. And we have lots of geographical indications which need to be protected. And today we have one of the finest speakers, R. Venkateshan. And the concerned person is a senior examiner of trademarks and the geographical indications. He is on behalf of the Government of India. He is coming and delivering lectures. Sir, we are honored to have you here. The institution is immensely pleased to welcome you. On behalf of the Board of Management and the Chairman and every one of us, I welcome you, sir. And last but not least, we have many learned people, the respective deans and the important officers of the university. On behalf of the university, once again, I invite everyone. And last but not least, all the teachers and dear students who are present here are also welcomed with a wholeheartedness. Thank you.
Thank you, sir. Now, I would like to invite Mr. Adarsh Kumar, a third-year student of BCom LLB, to introduce us today's resource person, R. Venkateshan.
A very good morning to everyone present here. Respected Dean Sir, Professor T.R. Subramania, our Director Dr. Vijay Praneshwaran Sir, all the dignitaries and head of other institutions of the CMR University, and my beloved friends. I welcome you all on behalf of the CMRU School of Legal Studies. I, on behalf of the CMRU KSCST IP cell, would like to extend our heartfelt welcome to our respected speaker of the day, R. Venkateshan Sir. Sir is a senior examiner of trademarks and GI. Sir has the experience of practicing as an advocate before the Honorable High Court of Madras for about 10 years. Sir has been working in this government institution, that is the Intellectual Property Office, since 2010. Sir has an experience of 12 years in this field. Sir, I welcome you once again to share your valuable insights on the topic IPR, trademarks, and GI. We are sure that this would be a very good learning experience for all of us. Thank you.
Thank you, Adarsh. Now, I invite R. Venkateshan sir to deliver the talk on trademark and geographical indication. Sir, you are on mute.
Sorry. Good morning, everybody. I am Venkatesan from Chennai. On behalf of Government of India and Intellectual Property Office, Chennai, we are thankful for the opportunity given by your university, your dean and your chairperson, and thanking you on behalf of our institution. Since that intellectual property rights have its own way of getting the students about the knowledge, we, Government of India, started to arrange a program all over India under the mission called National Intellectual Property Awareness Mission, which targeted 1 million people from all over India to be participated before the end of August this year. We are marching towards that goal. We will achieve that. Not only achieving that goal, at the same time, we making awareness among the students in the stage of schools, colleges, universities, etc. It will be helpful for the students who is having knowledge over the intellectual property rights. At the same time, it will increase their ability to have a knowledge over particular subject. So we move on to the subject now. Shall we start?
Yes, sir. Yes, sir. We have made you as a co-host, so you can share your slides.
Yes, thank you.
Yes, sir.
Are you able to see this PPT, first slide?
Yes, sir.
Yes. First, we start with our jurisdictional offices in all over India. In India, there are 4 metropolitan cities where we can get the application filed in Chennai, Mumbai, Kolkata, and Delhi. One more office in Ahmedabad, where it deals with only the application related to trademarks. So trademarks can be filed in all the other 4 metropolitan cities as well as in Ahmedabad. The mission before us is the National Intellectual Property Awareness Mission. As we in the introduction, I said this is the main aim for the country or the government to reach the people all over the India, especially the students, the college, university, even the schools. We are making awareness over this program. We start with the program with the subjects of intellectual property. This is the disclaimer of the presentation. I hope you can read this, make sure of these conditions. Now we see the subjects of intellectual property. First, we deal with patent. Patent means it will be granted to the person who invented a new thing, novel thing, not the discovered one or already existing process or goods. Then second one is the designs. Designs where you can get rights over a protection over a particular design. Even it is from the shape of the bottle to the shape of your car. It varies its design. And trademarks. Brand names has been registered under the Trademarks Act, and this protection will be granted to the trademarks registered proprietors. Then geographical indication. Geographical indication is the field where that product, that goods carries its own origin or the name of the place where it belongs to, particularly where it is coming from, we can identify. Then copyrights. Copyright is the right granted to the person or the owner of that copyright. You can say that author in the sense he can enjoy the right over that particular copyright, innovations, ideas, thoughts. Then he can also have that knowledge over a particular field. He can register its his or her in thoughts. It will be protected under the Copyright Act. Then semiconductor integrated circuits layout. This is a kind of protection. It will be granted to the IC, specially designed for electronic items. Then the protection of plant variety and farmers' right, which comes under the Ministry of Agriculture and Farmers' Welfare. The last one, trade secret. Trade secret is a secret maintained by the particular company so as to maintain their formula secretly, and they can stand their business and have the economic development over that particular product against the competitors. So these are all the subjects. We can discuss it one by one in the following slides. Before that, we have an idea what is the IPR and what that IPR is having in us right over a single product. We can use it in a example so that you can easily understand. This is the example for the better understanding of a intellectual property rights binder in a single product or goods, you can say. First one, we take that MacBook. This is the book or a laptop which includes all the intellectual property rights in it. First, we can see the LED display. This is the display. It can be protected under the Patent Act. Then body of the laptop. The body of the laptop. Here the MacBook has its own design, a unique one, which cannot be copied by others, and the same will be protected under the Design Act. Not only
Excuse me, sir.
Yes. Yes, ma'am.
Sorry for interrupting, sir. Slide has been not changing.
1 second. The first slide you got it, right?
Yes, sir. It is still the first slide.
You had seen this one, right?
Yes, sir.
You are able to see now. You are able to see now.
Sir, it's still in the first slide only.
Yes, yes, I am having that first slide only.
Okay, okay, sir.
I'm maximizing it. Then this is the disclaimer page. You can see now.
Yes, sir.
This is the subject of intellectual property rights. I have to start again. Shall I start from here again? If you want, I will start. Hello, madam?
Yes, sir. Yes, sir.
Yes. Now I am in the present page. You can see here different IPs in a particular product. For example, the MacBook you can see here from Apple company. In a single laptop, all the intellectual property rights is bounded there. For example, you can take the LED display, specially designed one for that MacBook that can be protected under the Patent Act, which is a new one, novel one, innovative one. So it will come under the Patent Act. Then design of that laptop, even not only the Apple MacBook, Samsung, Lenovo, all the company has its own design that can be protected under the Designs Act. Then the trademark brand name mentioned here in device mark as Apple, not only device mark, For as far as the trademark is concerned, it may be a name or a label or combination of thereof both. You can get a registration over a trademark brand name. Here they have mentioned that Apple sign, it can be protected under the Trademarks Act. At the same time, if it is a word mark, so for example, you can see that Samsung name will be there. They can have that name mentioned in that brand name column. Then Lenovo also there. So wordmark also protected under the Trademarks Act 1999. Then user manual granted by that particular company in related to that particular product, how to use, how to maintain that product, or how to how to use that particular product, that can be protected under the copyright. And then layout of IC. IC is the internal circuit available in every electronic item, so they can get a right over that SACL designs. So this is the example how a single product will be covered under the intellectual property rights as a whole. We move on to the first subject, starts with patent. A patent is an exclusive right granted in respect of an invention. We have to underline the word invention here, because only invention can be protected under the Patent Act, and the right can be granted to the particular inventions, not the discovered one or already existing one. At the same time, it be a novel one, so as to get a patent right over that particular innovations. Then which may be a product or a process. You can get right over to a particular product, even if it is a chair, you can get specially designed chair. It should be a specially designed chair, and it can be movable like that, or it may be having some special innovations in that, so that you can get a grant over that particular innovations, and that provides a new and inventive step. So way of doing technical solutions to solve a problem. At the same time, it will have the solution to get rid of that problem, that can be protected under the Patent Act. Then once that grant has been given to the patentee, he can enjoy a exclusive right over that particular inventions, and at the same time it will help him to stop others from making such kind of inventions, or copying, using, exercising, vending and importing of such products. So it will be an exclusive right for him to enjoy over that particular patent granted in favor of him, and he can enjoy the product or patent of the patentee for a period of 20 years. He can enjoy the right over that patent for 20 years and a limited period, and it will be the patentee's invention will be in the public domain after the period of 20 years exhausted. So there will be no renewal like that in patent, as we're doing in trademark and geographical indications. So it has the right, and it has to exclude others using your invention. So these are all the legal points we can see over the patent. Now we move on to the examples of earlier days of inventions that has been enjoyed for a particular period, and the same will be in now in the public domain. We start with the other countries' inventions first. You can see the left side of that column. You can see the Thomas Alva Edison name, and then Alexander Graham Bell. The right side will be their respective inventions. First, we see Thomas Alva Edison, who invented the phonograph. Alexander Graham Bell for telephone, Wright brothers for aeroplane, and Louis Pasteur for rabies vaccination, then Alexander Fleming for penicillin. So these are all the innovation, and the scientists they enjoyed their right over that particular invention for a period of a limited period. Now it is in the public domain. We can use it and enjoy that innovations. No one will restrict us to using this. You can see the inventions as on date. First one, it is a smartwatch. It is in playing a vital role nowadays. Then the second one, you can see a product which covers over the baby head. That product stopping the water flowing into the eyes of the baby. It's also a kind of invention. The third one in the right corner, you can see the drone. You come across that this is a kind of instrument used for making a photograph, then videograph, particularly the police personnel using it in that period of Corona period, you can say that. Then last one in the left corner bottom, you can see the shoe. This is the shoe which is specially designed for Michael Jackson, enabling him to bend forward while he was dancing. You can see the next example of the dancing, how he can use this one. Normally, we can slide forward for a 20 degrees normal limit. Using this shoe, the dancer can bend forward for a 45 degrees anti-gravity lean, only because of specially shoe, which will be in the stage in a secret behind the illusion. They base that each member and the shoe will join together, help him to bend forward so as to he can make magic, making magic over the stage. So it's also a kind of invention. Now we move on to the next. These are all the Indian inventions you can see. First one is the nano car. Then second one, famous Indian innovations for hepatitis vaccine. The third one is the artificial limb. First, you can see the nano car. This is the nano car specially designed for the people who is having a less purchasing power, maybe middle class people, they can dream. Then hepatitis vaccine. This is the vaccine used for less than $1 for the people who is having a less purchasing power. Then Jaipur food. This is the food affordable prosthetics. They can enjoy over that particular product. The people who is having a disabilities problem in their legs, they can adopt this kind of artificial limb so as to they can walk easily by adopting these products. So these are all the inventions by the Indians. We move on to the next subject, design. Someone is marking that screen, madam. Designs may be, in bracket you can see, it is an ornamental aesthetic aspects of an article, features of shape, configuration, pattern, ornament, or composition of line or colors. First, we have to see that it may be a shape. You can see the first column. It may be a shape of bottles. It may be an ornament. It's a kind of a new ornament. You can see that this is the ring, the specially designed one. Then this is the earrings. You can see that as a special design. Then the middle of that product, you can see the harpic. This is the harpic used for cleaning the toilets. You can identify without the name of the label of the product. You can identify using the shape of the bottle. So it is a vital role, and it is playing a vital role in identifying those products. Then designs will be protected under the Designs Act. Then this is the bottle. This is the bottle. You can see it can be a different kind of bottles. 1 second, I'm having some water.
Excuse me, sir. You seem to be muted. Kindly unmute yourself.
Yes. So the design is playing a vital role while the products and the name should be identified without the label. Like that, it has its own uh, right over that design. We can enjoy it. Then we move on to the other kind of designs in the other fields, like dress materials, cloth materials. You can see this is a kind of designs in all dress materials. They can how they are preparing. It is a treatment of materials from finished raw materials that can be changed to uh, finished goods. These are all the designs that can be protected under the Designs Act. Then articles, ornaments, then cup, designs cup. You can see the specially designed cup having its own design. This is the new, you can see this is a kind of new design. Then in the field of furnitures, these are all the simple examples for designs. Nowadays, we can come across many number of designs in the field of furniture also. Again, we move on to the shapes of the bottle. You can see the shape of a shampoo bottle of a particular company, how they are using this kind of shapes to their products. So each and every design that can be protected for its own making of it. Then we move on to the next subject, copyright. The copyright can be protected to the persons who are having a special knowledge over that particular subject and having a thoughts which can be protected under the Copyrights Act. First one, we move on to the literary works. Literary works means here it may be a writing, it may be a article, it may be a story, it may be in any kind of that literary works that can be protected under the Copyrights Act. Then paintings. Paintings also can be protected under the Copyright Act. Then photographs. Photographs nowadays you can see people are interested in having a wildlife photographs you can see. Then drawings. Drawings means you can have your thoughts in your mind, you can make it as a drawing that can be protected under the Drawings Act, Copyright Act. And at the same time, the films, feature films that can be protected once the film has been made ready, they can have their rights by registering their new films also. Then music and musical notes can be protected under the Copyrights Act. Then choreography and sculpture. These are all the other two kinds of items that can be protected under the Copyrights Act. So copyright here you can see in a legal format. It is an exclusive legal right granted to the creators, the expression of an idea. Your idea in the field of feature films or in the field of storytelling, story writing or painting, photographs, drawings, then music. So every department you can enjoy an exclusive right over that idea. Then copyright owner has the right to reproduce. He can reproduce or translate or adapt. For example, nowadays future films having its dubbing rights to the other states so that they can reproduce that film and translate to that particular language where they are doing that, and they can display the work. So it's a kind of a right enjoyed by that particular artist, and he can have the right over that particular idea. Here, there is no innovation; it is an idea. As far as the copyright is concerned, registration is not mandatory. But since copyright comes into existence as soon as the intellectual work is created, it is recommended to register a copyright for better enforceability of that particular copyright. Suppose you are having a issue over a copyright, then it can be registered one. It is a registered one. Then you can have a full right over that particular idea or thoughts that can be protected over the court of law. No documents will prevail over the registration in the copyright. So a certificate in the copyright will be a vital evidence for approaching a particular case, and it will be a vital evidence to show that they are using that copyright or idea in their name. The court will always decide in the favor of the person who is having or enjoying the right under the copyright granted to him. Move on to the next subject, trade secret. A trade secret is any practice or process of a company that is generally not known outside of the company. Suppose if you are doing a particular manufacturing work, you have to maintain such a kind of secret so as to maintain your product in a tact way. So if you are doing that kind of product or manufacturing that kind of product, it will help you in future so as to it will be make competitors to others. At the same time, it gives, the trade secret gives the company an economic advantage over its competitors. So people will have that in mind. They are making that such kind of product. Over that particular product, they can enjoy that secret so as to maintain their competition alive in that business, and they can enjoy the right over that particular formula. We can see that example so as to we can easily enjoy that product. Sorry, easily understand that kind of uh, subject you can enjoy. Sorry, you can see the next subject, for example, for trade secret in the next slide. Madam, sir, there are some disturbance, madam. They are marking and scratching that slides like a sketch like that. That can be removed, madam.
Yes, ma'am. Yes, sir. We are seeing into it.
You are also seeing that they are marking.
Yes, sir. I'll get it resolved, sir.
Yes. For trade secret, you can start with an example of Coca-Cola. Here you can see the Coca-Cola company having its secret over the production of a particular drink, which has its own taste, color, and aroma. Even the shape of the bottle they are preparing, that can be protected. So as to KFC also having some secrecy over that ingredients, what they are using and what level of ingredients they can use it for that better taste. And then McDonald's, MacBook. So these are all the examples you can see when you are having a trade secret to maintain that particular competition alive. So these are all the examples we can come across over that subject trade secret. Now move on to the trademarks. We are eager waiting for that subject. A trademark is a word, name, symbol, or device. It may be any word, any name, or symbol, or device. You can come across that first example I have made as a Apple. It is a kind of device. It is used for getting a registration for brand name. Second one, it may be a word name. For example, Samsung. Then it can be a Lenovo like that. It may be a name also. So it may be a word, name, symbol, or combination of both the word and the symbol can be protected under the Trademarks Act. So what gives the trademark as a right means it identifies the goods and distinguish the sources of the goods or services of one party to the others. Suppose we are planned for purchasing a product. For example, we can go for a purchase of garments. Definitely, we will choose for a branded item. So you are choosing a product which is branded one, that makes and identifies the branded items, and at the same time it makes the distinguish between the branded one and unbranded one. So the trademark or the brand name, once it is registered, it identifies and distinguishes the source of goods or services of one party from those of others. And at the same time, the goods and the services. In trademarks, there are classes which divides into 45 classes, so as to we can apply in which class we are having a business over that brand name. That can be decided at the time of filing an application. In which field we are practicing means, suppose as an institution, your university can be have a brand name that can be protected under the Trademarks Act. No, madam. I have to wait, madam. No issues, madam. I can continue.
Participants kindly be on the session. The speaker is expected to join soon.
Now you can able to see, ma'am.
Yes, sir. Now it's fine. Thank you so much, sir. You can continue. Thank you, sir.
Yes. First, we start with the trademark with the concept. As we discussed, the mark will be a word, name, symbol, or device. So, our combination of all the word, name, symbol can be granted a registration under the Trademarks Act 1999. At the same time, it identifies the goods and services from one person to other person. And goods and services means, as I mentioned, there are 45 classes is mentioned in the Trademarks Act 1999. All the classes will fall under each classes as its own merit over that particular goods and services. For example, as an institution, you can also file an application for trademark under the service class, since you are doing a service for education and providing training to the people who are joined in your institution. So that falls under the class 41. As I said, there are classes from 1 to 34 and 35 to 45. Here there is a division of two things. One is goods class, the second one is service classes. The goods class starts with 1 and ends in class 34, and the service class starts in 35 and ends in class 45. So once you decided in your business or for your client you are filing an application, it will be decided by way of goods description. Suppose your institution filing an application means you have to choose the second section of service classes. First is goods classes, second one is service classes. From 35 onwards, service classes starts. 35 starts for wholesale and retail services of a particular product. Even import export will come under that class. Then 36, 37, like that, it will goes on to 45. Since you are an institution, you have to file an application under class 41 as a service class under the heading of providing education and training, etc., entertainment services. All the services you have mentioned in your institution, that will be comes under as a service class. For goods class, suppose people who are doing chemical work, chemical goods they are preparing means they have to apply in class 1. For class 2, the paint will be there, and class 3, they will file an application for cosmetics. Class 4, lubricants. Class 5, cosmetic item, sorry, for pharmaceutical item. So all the classes from 1 to 35, 34 goods classes, from 35 to 45 service classes. So the goods and services will be the uh, subject how to differentiate with these tools. Then it will be in the application details. What are all the goods you are going to file an application for registration, and at the same time the service classes for class 35 to 45. Next, we see the form of intellectual property. The trademark will be the form of an intellectual property rights. It enjoys the right of that particular registered proprietor. He can file an application for the registration, and at the same time, they can also file an application for renewal as well as the time means that is after date of application, from the date of application 10 years will be there for renewing that particular application for registration. Then allows the trademark, the brand name will allows a business to build in goodwill among that particular people or section of people. It allows the businessman to build public goodwill. Once the brand name has been registered, the people automatically turn to that brand names so as to that keep purchasing capability of that particular people will be increased. And then at the same time, it helps the registration of trademarks will help the brand reputation in the goods and services it deals with. As we mentioned, we will always choose that branded items. That is the reputation of that branded item, and at the same time, it helps the identifies and the source of goods and services. Most positively, the goods and services, that once the mark has been got registered, it assures all the customers about the quality of that particular goods and services. As we discussed, we choose that not registered, as we discussed, the registered trademarks will be helpful for them to identify the brands only because of that brand name has been registered. At the same time, it assures, because of that brand name registration, it assures the customers to increase the quality of their goods or services. So once the brand name got the registration over that particular product, it assures the customers about the quality of the particular goods or services. Now we can see the examples of trademarks which got registration. You can see the famous McDonald's, Pringles, then Samsung, Facebook, Starbucks, Pepsi, Coca-Cola, Dell, BMW, Visa, NBC, Levi's. So these are all the brand items which got registered in all over world. At the same time, it will help them protect themselves from getting copied by others. One second, I have some water. Now we start with the subject matters of trademarks. Trademarks including service marks. as we discussed, not only the goods that can be protected as well as the service also protected under the Trademarks Act 1999. And second one is the collective mark. Here the collective mark means people join together to form an association or partnership of company. They can collectively file an application as a branded item that can be protected under the Trademarks Act as a collective marks. Then certification of marks. Here the certification of marks may be wool mark, ISI mark, UG mark, like that. Then silk mark that can be protected under the certification trademarks. Then a tagline and slogans can be protected under the Trademarks Act under the heading of tagline and slogans. For the example, you can see the tagline for Pepsi. You can see the Pepsi tagline is Dil Mange More. Then slogans for trademarks like Nike, you can come across that, just do it. These are all the taglines, and then slogans can be protected and registered under the Trademarks Act 1999. Then non-conventional trademarks. For example, smell mark, sound mark, 3D shapes. So these kind of marks can also be protected under the Trademarks Act 1999. For example, sound mark, the MGM Lions Roar, Yahoo Yodel, and the Nokia Tune has been granted protection under the Trademarks Act 1999 and other trademarks in the other countries, as well as the 3D and shapes. You can see the shapes of the bottle that can be protected in a 3D view that can be given protection. Then moving marks, the zoom in view of a female statue at the beginning of every Colombian pictures, you can see that motion picture moving marks that can be protected under the patent act, USPTO of United States, 1975 of 999, that can be protected. So these are all the non-conventional trademarks can be protected under the Trademarks Act provisions. You can see the examples in the following slide. Next slide. First, we can see the motion picture, Columbia picture. This is the picture that can be coming at the time of beginning of each feature fill-ins showing. It's a kind of a motion pictures that has got registered under the USPTO patent trademarks. Then sound mark, the roar of a lion. That company belongs to Metro Goldwyn Mayer. The sound, the lion roars sound that can be protected, and the same has been protected. Then the shape of the bottle, 3D shapes. The Coca-Cola bottle got its registration. That 3 view of that particular bottle can be registerable. When you are applying for an application for registration of a trademark, you have to provide a 3D shape of that bottle, front view and rear view, and then side view of that. The 3 dimension of that product can be given, so as to they can examine that application and give protection to your registration. Then tagline, as we mentioned, tagline can be registered under the Trademarks Act. This example is Dil Mange More. Then certification marks. Here the example of certification mark is Bureau of Indian Standards, like that ISI, then AGNOR, like that wool mark, silk mark. Under these categories, trademark may be granted. Then service marks under Naukri.com and then Google. These are all the other examples for registration of trademarks. We can move on to the next slide. Here you can see the find out yet how to find a good trademark. Once we decided to file an application for registration of a trademark, we have to keep it in mind that the mark should be distinctiveness. It has its own distinctiveness than inherent. So if you are having an application or a goods or a service brand name, it should be distinctiveness. For example, you are dealing with some product called under salt that can be file an application under food items, then under class 30 or 29. That time you have to give the only goods name. So it should be a goods name, not rather than a quality of that goods. Suppose that you can't add pure over that trademark, what you have decided, then best, like that. So avoid these kind of words like best, pure, and all those things. Then inherent, it should be an inherent mark so as to easily get acceptable. First thing is we have to avoid the laudatory words like best, pure. Then it should be an inherent mark. Then acquire distinctiveness. Once you have applied an application uh, that you are adopting a particular trademark and it is using before the date of application for a period of 3 years, for example, you can take, then the mark itself acquired its distinctiveness. At the same time, it acquired uh, uh, among the people a secondary name. So it has its capacity to file an application under the head of acquired distinctiveness. So even then that section 9 provision can be waived using that provision, acquired distinctiveness. The provision says no mark will be, no trademark will be refused on that ground that it is not used, it is not, no, under section 9(1) of the Act, since the mark has acquired distinctiveness. So if you are using the mark before the date of application, it acquires distinctiveness. It can be a valid point to get a registration, valid registration of that particular product. Then honestly adopt, not deceptively similar. The next one is you have to choose a brand name. It should not be a earlier one, and it should not be having a registered in the registration department or a registry. So we have to carefully adopt that thing. Uh, we have to choose a mark which is already existing, so as to we can avoid litigation. Then honestly adopter or coined one. Suppose you are using a particular brand name, at the same time the people from other side or other state without knowledge of that particular name they are using, then it can be uh, acceptable one. So you are using the mark and adopting the mark honestly, so you can get a registration under the heading of honestly adopted mark. And coined one. Coined one means here it should be a coined mark which has no meaning at all. Once the mark, you have make a mark which is based on your idea. Like for example, if two partners are there, they having joined together to form a partnership, then you can, for example, I'm saying you can add their names, first name, last name, like that. Then you know, combine together to form a new word and a coined word. It has no meaning at all. That time it can be allowed. Then not similar to already existing mark. This is this is the similar point raised, not deceptively similar mark. So not deceptively similar and not similar to already existing marks or in the same footings, then it can be avoided so as to you can get a trademark easily without no litigation at all. Then before adopting a new mark, it is advisable to have a search conducted and evaluated. It also avoids unnecessary litigation. Once you chosen a brand name, you have to do some homework. For example, if you are choosing a brand name under the class 41, that is for service class for providing education, you visit our website, that is ipindia.nec.in, where you can find a portal called public search. You have to put the name there. At the same time, you have to give the class details also. For example, you are filing for a service for education. You have to put the name and then a class details as 41. You have to search it. That time you will get a number of registration. If it is similar in nature or identical in nature, the list of registered trademarks will be there, and you have to avoid such kind of trademarks if it is earlier pending or registered before the registry. So it is advisable to have a search conducted in our portal to avoid such kind of litigations. So I think you may be clear over this point. Before adopting a new mark, I am repeating the same thing again. It is advisable to have a search conducted in a particular class or groups. Then you have to make report over that particular limited trademarks. Then you can have a better mark to be chosen, avoiding the earlier trademark. So it helps you to avoid unnecessary litigations in this matter. Now we see the examples in relation to deceptively similar mark. You can see the deceptively trademarks. This is mentioned as Pant Boy. It is deceptively similar to Playboy. It's a kind of famous mark. Then Nike has been mentioned as Hikey here with a slight deviation of that tick mark, which should be avoided. Then KFG, this is the reproduction of the KFC with the same combination of colors and the same kind of what we can say that appearance. Then Puma has been mentioned as foam, and then leaping.
I request participants to be on mute.
You can see the last one. They have copied as mentioned as foam, as a puma derived from that. You can also see the leaping of a jaguar. So these kind of things we have to avoid while deciding a trademark or brand name to be registered. This is our website. You can see that where you can find a public search. You can click there for a public search portal. You can get a trademarks name is there, where you can find the class details in the public search. Then prohibited marks. Suppose you are choosing a name, for example, I'm saying you are choosing the brand name as a Balaji. That is a prohibited one, and the same is mentioned in the list of prohibited trademarks. Then well-known marks. Suppose you are choosing a name, for example, again I'm saying Bajaj. That is a well-known mark, and the same has been declared as well-known mark. We are forbidden from choosing that kind of names. The list you can find that list over that. What we call well-known marks details. Then list of non-conventional trademarks. The chemical names, you can have that list over that page. You can avoid the name of that chemical name of that particular goods under the pharmaceutical preparations. So these are all the things you can do as a homework before filing an application for registration of a brand name. Now we move on to the filing procedure. The act which prevail over that brand name registration will be the Trademarks Act 1999, and it will be mentioned the rules and regulations or procedural regulation is mentioned in the Trademarks Rule 2017. Then half of application fee in case of individual startup or small enterprises. Suppose if you are an individual, you can get a concession of half of the fees. For example, the government fee is 10,000, then you can get 5,000 for that fee amount. Then if you are a startup or small enterprises, you can also avail that exemption, provided you have to give the certificates. If you are a startup, the Ministry of Commerce and Industry will provide a certificate that you are a startup. Small enterprises, MSME will provide a certificate mentioning that you are a small enterprises, so that you can get the benefit of 50% off in your fees. Even then, if you are choosing through online, you are choosing online applications, then you can get an additional 10% of your fees exemption. We decided that 5,000 will be paid for that individual startup and small enterprises. If you are choosing it through online, it will be 4,500. The form which is going to file an application will be TMA, form TMA. It will contain all the details, particular names of your details of your business address, name of the applicant, and the goods description. If you are filing an application for service classes, service description will be there. Then if you are doing online, you can get that amount deducted. If you are doing through offline, you have to file an application with the A4 size typewritten and printed with Hindi or non-Hindi or English words. You can also file your application in regional languages, maybe in Tamil, Kannada, or any other language. That time you have to provide the translation of that particular brand name, what you have mentioned in that application. Suppose you are using a mark under the acquired distinctiveness over that particular product, you have to give a statement of use, that is an affidavit you have to file in support of your use, and along with the documents from so and so period you are using that particular name or brand name. So it will be accompanied with the application with TMA. We move on to the next slide. Once you file an application, you can make a you can mention TM as stating that the mark is, the brand name is pending for registration, and at the same time, or once you got registered over your trademark brand name has been registered, you can get the mark registered. Certificate will be in your hand. That time you can choose it this letter R, and you can use it along with the circle. It denotes that you are the registered proprietor of that particular brand name. You can see this circle in R, all the registered brand names in our day-to-day life. When you are having, for example, I am saying the Bisleri bottle, when you are having that bottle in your hand, you check it. After that I, the top of that you can see the symbol of R within a circle. So these are all some procedures to be followed. If suppose you are not having registration certificate in your favor, you have to avoid such kind of mentioning, and at the same time it is punishable offense. You are doing with unregistered trademark, means you are putting R in a circle for the unregistered brand names, means it will be punishable offense. So please avoid those kind of things while you are using your brand name. Now we move on to renewal and post-registration management. First, as we mentioned or as we discussed earlier, the mark will be valid for 10 years. Once you file an application, it will be valid for 10 years from the date of application. It can be further renewed indefinitely. That is 10 years. Each 10 year you have to file an application for renewal, and there is no limitation for that. Indefinitely you can use it. Then trademarks can be transmitted by operation of law. Once you registered your brand name in your favor, you can sell that brand name to others, like other properties you are selling, provided there is a procedure to be followed in trademarks. You have to file an assignment. You have to enter an assignment deed with the person who is willing to get that mark in his favor as a subsequent proprietor. So the details will be in the assignment deed, will contain about the details of that assigner, the owner of that registered trademark, then the details of the assignee, the details of the person who is going to get the mark with him as a subsequent proprietor can be mentioned. Then consideration amount. They have to mention the people who is going to get that mark in his favor has to pay a consideration to that product or brand name, and at the same time the assigner, you have to accept or acknowledge that brand name, that consideration has been paid to me and I acknowledge the same. And the goodwill, the trademark goodwill, along you have to transmit that product brand name along with the goodwill. And the consideration amount, calculating that consideration amount, you have to pay the registration fee prevailing over particular state. So these are all the points to be mentioned in that assignment deed. And the assigner has to file an affidavit stating that there is no cases pending before any court of law or litigation before any court of law in the present brand name or registered trademark. And at the same time, they have to give a affidavit. Particularly, it should be in a form of affidavit. It should be notarized one, so as to making that document legally binded to the proceedings. Like that, these are the procedures that can be acceptable and followed by trademarks owners and the trademark proprietary registered proprietor. They can alienate that property to other person. And Trademarks Act 1999 also provides for administrative, civil and criminal remedies. Once you are having a registered trademark in your favor, you can file an application if the other person or some other person having copied your trademark, and at the same time you have a remedy under the administrative remedies. You approach the registry where you can file a opposition to stay that stop that mark by filing an opposition of acceptance mark. It is called administrative. Once you oppose that mark, that opposition proceedings will start there, and you have to file an affidavit. They have to file an affidavit, and you have to both have to file the evidence, respective evidence, to conduct that proceedings. And finally, after hearing both the sides, it will be decided, and the person who is doing the wrong thing will be expunged, and the person who is doing the manner in way in which is the rightful one, that can be granted registration. Then civil and criminal remedies. Like that, if you are having a registered trademark brand name in your favor, you can file an application or a suit before the district forum, not below the level of district courts. You can file a suit for injunction. It may be temporary injunction or permanent injunction, and at the same time criminal procedures also be followed. So if a person copying your mark, making duplication over particular brand name, you have the remedies under the criminal remedies. That time you can approach that local jurisdiction, police station. You can make a complaint over that person who is doing your duplication work of your brand name. Based on your complaint, the police will file an FIR. Then it can be forwarded to our office. The officer not below the rank of deputy superintendent of police, they can get the opinion, approaches for a opinion, for an opinion whether that mark that person is copying or not will be decided, and comparison of both the marks. Based on that, they will provide opinion over that complaint. And same, and section 115 of Trademarks Act, the police can, based on that opinion, they can proceed further by searching, seizing of the duplication articles, like that. And criminal proceedings will start there, and it will be in court of law for deciding the criminal proceedings also. So these are all the procedures to be followed, and keeping in mind after the registration and prior to that registration, what are all things we have to do, all the things we have discussed under the Trademarks Act. Now we move on to the next subject, geographical indication. The geographical indication is a sign used on products that have specific geographical origin and possess qualities or a reputation that are due to or that origin. The product which carries its own name or origin of a particular region or name of the place, and the same is called geographical indication. For example, from France, the champagne is the name of the place, and whiskey from Scotch from United Kingdom, then Napa Valley wines from USA, tea. The tea is the product here and the goods here, and it is from Darjeeling. This is the name of the place where it's come from. These are all the few examples of Darjeeling tea is the best example, since it is the first registration in geographical indications of India. So we can see the procedures one by one. The geographical indication only deals with goods, not the services as mentioned or discussed earlier in the trademarks. It deals with only goods items from class 1 to 34. It deals with, and then the geographical indications has been divided into 3 categories, which may be agriculture product, then natural product, and manufactured product. You can see the agriculture product in the examples in the next slide. So as to natural manufactured products, that manufactured products further divided into subcategories like handicrafts, which includes handloom, textile, goods of industry or industrial goods, foodstuffs, and wines and spirits. So we have to keep in mind that the geographical indication deals with only the goods item, and the same has been divided into 3 categories: agricultural, natural, and manufactured one. And at the same time, again, the manufacturer heading is divided into subcategories like handloom, textile, goods of industry, and industrial goods like foodstuffs, and then wines and spirits also comes under the products. We can divide into 3 types. You can see the examples in the next slide about these kind of products. First one, agricultural goods. For example, basmati rice, Darjeeling tea, Kangra tea, Alfonso mango, Uttarakhand Tejpat. So these are all the examples in for agriculture goods. Natural goods, marbles are available naturally. The name of the place is Makrana. The Makrana is the place where that marble is available in Rajasthan. Then examples in manufactured goods, handicrafts, pottery, stone sculpture, wood carving, metal craft are the few examples under the manufactured goods. Blue pottery of Jaipur, Mahabalipuram stone sculpture, Konark stone carving, Agra marble inlay work, then Chennapatna tiles. You can see that each goods they are dealing with, which has its own name of the place or origin where it originates from. Even in textiles and handloom, you can see saris from Banaras and Gorkades, then Pulkari, Pochampalika, Mysore silk, Pathan Potala, Kashmir Pashmina, Muga silk of Assam, and Kashmir Suzani craft, etc. So here also you can see the same thing. The goods item will be there at the same time. It keeps along with as a prefix or suffix. The name of the place will be there. Mostly the prefix will be the name of the place. Like in foodstuffs, you can see Dharwad Peda, Hyderabad Halim, Bangalore Rasgulla, Bikaner Bhuja, and Ratlami Sev. The Sev is the product here. Ratlami is the name of the place in Madhya Pradesh. Next, we'll move on to industrial goods. Coimbatore wet grinder. Wet grinders are famous in manufacturing place is called Coimbatore, where it is famous for these kind of products. So the prefix will contains the name of the place as Coimbatore wet grinder. Then Sissar from Meerut. Then Attar from Kannuj. These are the few examples for industrial goods. Move on to the next slide. Who can apply a GI? Here, by any association of person or producers. Unlike in trademarks, the single person, single proprietor can file an application, but here the persons or producers can file an application. No single person is allowed to file an application as a GI applicant or person who is enjoying that right over that particular GI cannot file an application. So always keep in mind that it should be a association of person or producers. The application you can file with the registry GA 1A to 1D. It should be accompanied by prescribed fee of rupees 5,000 per class. Like that, as we discussed earlier, here the goods class only be maintained in trademark. Sorry, GI. No service class is available in GI. Then authorized user. You can see that by a producer jointly owned by the registered proprietor of that GI, you can use it. So, as we mentioned in the trademarks, you can see that the person who is enjoying the right as a brand owner can alienate that product or assign that brand name to the others. But here it is not possible. Only authorized user. Two things you have to maintain. Two things you have to keep in mind that in trademarks there will be a class details. There are a number of service classes. Second one, single applicant can file an application. Here, a group of persons will be file an application, and GI will deals with only the goods items, not the service classes. So these are all the two differences we have to maintain in our mind while processing the application. And then you have to file an application in GA called authorized user. You can use it as a authorized user. For that, you have to file an application under GA Form 3A with a prescribed fee of ₹10. So once you are interested in that particular product, you can use it with the consent of that registered proprietor of the particular product, or GA, Association of Person. The registry will scrutinize your application and grant you a term called authorized user. So these are all the procedures and the difference between the two subjects. Now we move on to the geographical indications examples. First one is Darjeeling tea. As we discussed, Darjeeling tea is the first GA granted to that tea product. Then natural goods, marble from Makrana in Rajasthan. Then Bobli Veena, Bastar Dokra, Venkatagiri Handloom, Narayanpet Handloom Sarees, Madurai Malli. Here in Tamil Nadu, Malli is famous for Madurai. So as to registered in GA tag also they got. Then Wayanad Jilakasala rice. Then Surat Zari crab. Oranges from Nagpur. Again tea from Nilgiris. This is the Darjeeling tea you can see. It will be based on that climate, then soil, then aroma, taste, all those things will be considered while granting the GA. Then this is the natural product example, Makrana marble. Then Ratnamisay from Madhya Pradesh, Kanjipuram silks from Kanjipuram in Tamil Nadu, a world famous tag that has been protected under the GA also. You can see the Kanyakumari cloud, then Tirupati Laddu, Madalam of Palakkad, from Karnataka, Mysore sandal soap, Pattamade Paul. From Tamil Nadu, you can see Dindigul locks, Kovilpatti Kadalanittai, Sirumalai Hill Balana, then Kodaikanal Malai Pundu. From other states, the Putlis of Rajasthan, Bog print of Madhya Pradesh, Bengal Pat Chitra, then Cherial paintings, Bidri ware, Varli painting. So these are all the few examples of registered GI. We move on to the next slide as a whole. We can discuss about that validity of each subject. As we discussed, patent will be valid for 20 years of term, and there is nothing called global or international patent. Then designs will be granted to a particular model. It may be a bottle, it may be a car, it may be a laptop. It will be based on the designs, which will be unique one, and at the same time it will be valid for 10 years plus 5 years for their renewal. Trademark will be available in the lifetime. Indefinitely you can use it, provided you have to file an application for renewal and each 10 year of that trademark, calculating from the date of application. Then GA, indefinitely subject to renewal. So trademarks and the GA will be the same footing. It can be renewed indefinitely, provided we have to file an application every 10 years, once in every 10 years. Then copyright will be granted to that author a period of lifetime of that author plus 60 years. The family will get that royalty over that copyright after the author lifetime. Who can apply? Except GI, the person, firm, partnership, small entity, and a body incorporated can file an application for all the subjects. Except GI, the association of person will file an application for registration of GI. Then all IP rights are territorial in nature. So you can get an enjoyment over limited area restriction over that particular product, like territorial in nature, you can get the registration to enjoy your legal rights under the intellectual property right act. So we end the program here. Thank you very much for your kind cooperation. Hope you will see in future also in this regard. And once again, thanking your institution for giving an opportunity to make the subject a successful one. Thank you one and all. Thank you very much. If you have any questions, please ask me. I will be waiting for you a question to answer.
Participants can post the questions in the chat box. If participants are having any questions, they can put it in the chat box. Sir, you are on mute. So we have one question from Maria. How do we tackle the issue of rising trademark trolls?
Pardon, madam?
We have one question, that is, how do we tackle the issue of rising trademark trolls?
Trademark issues.
Issues of rising trademark trolls, sir.
You write it, madam, in the box. Okay. I can't get your words. Trademark.
So the question is posted in the chat box. You can also see this, sir.
They have posted.
Yeah.
How do we tackle the issue of rising trademark trolls? If it is a registered one,
See, then you
Maria, you can unmute yourself and ask the question. Now we'll move on to the vote of thanks. I would like to invite Adish, 5th year student of BLLB, to deliver the vote of thanks.
Thank you, Harshita. It is indeed my privilege to be delivering this vote of thanks to all the people who are involved in making this webinar a success. I would first of all like to thank our guest speaker, Mr. R. Venkateshan sir, for giving such an insightful lecture on trademark and GI. Sir began by briefly explaining the different intellectual property and also gave us an example of how a single MacBook, Apple MacBook, holds various IPRs. Sir then went on to discuss in detail each IPR and explained the meanings, its essentials, and the duration of protection which it holds. Sir also gave real life example of trademark and also dealt in much detail the GI and trademark aspects and its various essentials and intricacies. Sir also gave examples of how there are currently various GIs which are held and how there are around 45 classes in trademark and different goods in GI which are registered in India. I would like to once again thank you first. Thank you, sir, for such a knowledge enriching session. Further, I would like to thank our beloved Dean, Sir, Dr. T.R. Subramanya, for always supporting students in all our endeavors and constantly organizing such sessions. I would also like to thank beloved Director Dr. Vijay Praneshwaran, Sir, our faculty coordinator for CMRU, KSCST, IPSN, Miss Vidya MN Ma'am, and student coordinators Harshita, Adarsh, and Maria for their contribution. I would also like to extend my sincere gratitude for all the heads of other institutions of CMR University for their presence and all the faculty members for their support. Last but not the least, all the students for patiently listening to the session. And thank you everyone for making this webinar a grand success. Have a great day ahead.
Thank you so much, sir. Thank you.
Thank you, one and all. See, you can wind up here.
Yes, sir.
Thank you.